that the Scottish nationalists will say, oh, but international law allows every country to have the right to self-determination. Oh, it's written in law, and so on and so forth. Well, what's all that about? And the reason it came into our consciousness recently was because, believe it or not, that's one of the arguments that the Scottish National Party are taking to the UK Supreme Court. They are claiming that under the International Covenant on Civil and Political Rights, which was ratified, which was agreed upon by the United Kingdom in 1976, that Scotland has some sort of international right to self-determination. Well, what does that covenant actually say? It says this, quote, all peoples have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social and cultural development, close quote. Well, does that somehow give the Scottish National Party the right on its own to have a second referendum? As I say, that's an argument. It's one of the core arguments that's being submitted to the UK Supreme Court. Well, actually, we're here today to tell you, quite frankly, that self-determination under international law does not apply to Scotland's situation. Let me explain. Is there a country in the democratic Western world that has wrestled with this question recently? Has a Supreme Court of a democratic Western nation looked at this question and come up with an answer? And that's the first thing that we would look at. And the answer is yes. In 1995, Quebec had attempted to separate from the rest of the Canadian Federation with a referendum. And in 1998, Canada's Supreme Court looked at this covenant and adjudicated upon it, made a judgment upon what it actually meant and whether or not it was relevant to Quebec's situation. And they basically came up with the fact that the concept was not intended for countries which already have internal self-determination, which already have internal democracy. Let me read out the judgment for you. The court's conclusion said, quote, a right to succession only arises under the principle of self-determination of people at international law, where a people, inverted commas in the text here, is governed as part of a colonial empire, where a people is subject to alien subjugation, domination or exploitation, and possibly where a people is denied any meaningful exercise of its right to self-determination within the state of which it forms a part. In other circumstances, people are expected to achieve self-determination within the framework of their existing state. Quote, a state whose government represents the whole of the people or peoples resident within its territory on a basis of equality and without discrimination, and respects the principles of self-determination in its internal arrangements, is entitled to maintain its territorial integrity under international law and to have that territorial integrity recognised by other states. And it was saying there that Canada does exercise internal self-determination. All parts of Canada exercise internal self-determination on a basis of equality and without discrimination. And everybody in Canada is respecting the principles of that in its internal arrangements. And so this idea that international law somehow demands that Quebec can break away isn't correct, because Quebec is not part of a colonial empire. Its people are not subject to, quote, alien subjugation, domination or exploitation, and they already possess, in terms of equality and non-discrimination, they already possess the means to have their point of view known. And so they have to work that within the bounds of the existing state that they find themselves in, rather than appealing to international law. So we can state very clearly, to conclude, that under international law, the International Covenant on civil and political rights is not a relevant document for Scotland. Scotland does not meet the requirements of being part of a colonial empire. It does not meet the requirements of being subject to, quote, alien subjugation, domination or exploitation, despite what some of the nationalists might imagine. And it certainly, from our perspective, does not apply to a country which self-determined in 2014 overwhelmingly to stay part of the United Kingdom, and which then subsequently self-determined in 2015, in 2017 and in 2019 to send representatives to the British Parliament. So the right of self-determination under international law does not apply to Scotland's situation.